if we think about the metaverse as a fully immersive digital world where people can work, play, and even live, a question that comes up fairly early on is what law applies to those fully immersive digital worlds. So if something goes wrong in one of those worlds, if there's a dispute between people living or working or playing in those worlds, what law do you turn to resolve those disputes? Now, I think part of the answer to that is to be found if you look at the terms of use or the platform terms that, generally speaking, you will click to accept before you enter one of these worlds. So I've put up on the first slide there a link to the Pixie Links terms and conditions, and also a link to Decentraland. But both of those are fairly well-known metaverses, and Decentraland is actually the world's largest decentralized metaverse. Now, if you have a moment to look at those after this webinar, what you will see is that there's actually nothing very remarkable about those terms and conditions. They are really the same kind of terms and conditions as you would expect every time you sign up to a technology product or a technology service. They're sort of disclaiming liability and they're limiting down warranties as much as possible. But what they have, or certainly what Decentraland has as well, is a fairly well-developed content policy, or what I would call an acceptable use policy. And what that does is it sort of sets out some rules for how you must behave on Decentraland, and essentially what you can and cannot do. So, for example, it talks about not introducing illegal content, no libelous content, no hate speech, no hate content, and it places restrictions on other types of content, such as gambling-related content. But I think even that sort of content policy is not particularly unusual, and it's the kind of thing that I would expect to see if I signed up to a sort of social media site or any other site which was accepting or allowing user-generated content. But I think what we're going to see in the metaverse is these acceptable use policies, these content policies, really being expanded, really growing until they almost become a set of private laws, and private laws which really govern life in those fully immersive digital worlds or metaverses. So I think that's what we're likely to see. But even with the most sophisticated set of private laws, it's also inevitable that those disputes are going to spill out into the real world. So they might be disputes about virtual goods, might be disputes about virtual property, and they may even be disputes about civil and criminal wrongs which were committed in the metaverse. So the question then becomes, whose courts do you look at to decide those sorts of cases? And what we've seen so far is those cases being determined, being tried in the courts where the platform provider, where the service provider is based. So typically where their servers are or where they're based. But even that may not be the greatest solution. Sometimes that may not be suitable, may not be acceptable. And on other occasions, it may just be difficult to work out exactly where that platform operates. So another idea would be to look where the user or the avatar is actually based. And I think also going forward, what we're going to see is a development of either case law and or regulation, which is really helping us, telling us where to bring those sort of cases which originate in the metaverse. So that's something to look out for. If I can have the next slide, please. The metaverse in many ways, a bit of a gift for lawyers, absolutely bristling with potential issues, potential legal issues. And I put some of them on the slide there. I mean, some of them are very real, very practical, and others are a bit more hypothetical, a bit more academic, at least at this fairly early stage. But for today, with limited time, I'm going to concentrate more on IP and intellectual property agreements, and maybe touch slightly on data privacy as well. So if we can move on to the next slide, please. So I've set out there a fairly typical grant of license clause from an IP agreement. This one is actually a license of copyright. So what you've got going on there is the licensor granting to the licensee a license under its copyright to do certain acts in the territory. Now, just make two observations about that sort of clause related to the metaverse. The first one, I suppose the most obvious one, is the definition of territory, because territory is traditionally defined as a country or countries, could be the UK, could be the European Union, or even the world. So the first question becomes, does territory include the metaverse? Which I think at best is going to be arguable, is going to be ambiguous, and I think is even more difficult where you start talking about a world which is kind of semi-virtual, semi-real, perhaps if you're using augmented reality to generate that world. But that's that sort of problem with new technology challenging, stretching the words in contracts is not a particularly new one. And we've certainly seen that's the same sort of problem with all sorts of new technology, DVDs, CDs, and I'm also just about old enough to remember that when entertainment in air traffic became a real thing, there was a real tendency to sort of take that flight entertainment and to deal with it separately to rights in sort of more traditional areas. And the other thing I think to say is, looking at this clause, the scope of use, so where that copyright can be used by the licensee, is fairly wide. Maybe it's a bit wider than most licensors would like, but I think that need to narrow the scope of use is going to be much more of an issue when we get into the metaverse. So, for example, if you think about a children's brand or a brand which is really aimed predominantly at children, you're really not going to want that brand to be used in unsuitable contexts, such as games depicting violence or sex. So you're going to want to prescribe in your license agreement what can and cannot be done with that copyright or with that IP right. So bring on the next slide, please. So so staying with IP agreements, I think the main thing is you've got to be looking at your IP agreements and working out whether they are really suitable for the metaverse. As I say, definition of territory is going to be a big issue. You need to make sure that works, and you try and remove the ambiguity for the metaverse. From a licensor's point of view, I think what we may see, and indeed what we're beginning to see in some aspects, is a move toward licensors licensing the metaverse separately. So almost treating the metaverse as a separate country, a separate territory, and dealing with that separately, and then dealing with sort of traditional real worlds, real territories in separate or under separate licensing arrangements. The licensee fundamentally is going to want certainty. So it's going to want to ensure that the definition of territory is wide enough, is robust enough to ensure that it can do what it needs to do or what it wants to do, not just in the metaverse as it exists today, but in the metaverse as it may expand. So there needs to be a certain element of future proofing there in that definition. But I think whether you're the licensor or whether you're the licensee, the key thing really is to call out metaverse specifically and really get into whether or not that's covered. Scope of use, dealt with that already, so I'll move through that. And then I think a big issue is going to be ownership of IP and identifying the licensor. So I think increasingly we're going to see IP, whether that's content or whatever, which is either created by artificial intelligence, and it's going to be difficult to work out who the owner is, who you're taking the license from, or it's going to be created as the result of collaborations. And one thing that we are seeing from the metaverse is businesses who wouldn't previously have thought about collaborating suddenly find it really useful, really convenient to collaborate in the metaverse. So there's going to be some issues around the ownership of that kind of IP as well. Quickly talk about term and termination. I suspect that what's going to happen with the metaverse is that because it's so sort of quick moving, so rapidly evolving, there's going to be a move towards either shorter license terms, project-specific license terms, or at the very least, license terms which are regularly reviewed to see if they're still sort of fit for purpose. I think that's a trend we're beginning to see already. And then finally, royalties. I think royalty models are going to have to be reviewed. We're certainly seeing a move towards smart contracts where the IP owner, the IP user, is automatically compensated every time the IP is used. But I think in addition to that, we may well find ourselves looking a bit more at a kind of influencer type model where there's a bit more of a premium on user engagement as well as simply sort of sales of products, sales of services. So I think we're going to see that kind of thing coming in as well. We can have the next slide, please. So yeah, I haven't really got a huge amount of time to look at all of the various data privacy possibilities, but I was going to just touch on a couple which I think are important, and I think also data privacy is going to be very important in the metaverse. And the first thing I wanted just to talk about is the nature of the metaverse, which I think is going to make it very difficult to identify who is who and who is doing what. So, data privacy lawyers will know it's always very important to identify who the data controller is and who the data processor is, so you can tell who's doing what, who, for example, is going to be in charge of putting up the privacy notice or the privacy policy, who's gathering the consent, and so on. But in the metaverse, what you're going to have is a multitude of entities with very different, often complex relationships, which I think is going to make it very difficult to identify those individual roles. Go to the next slide, please. And the other data privacy issue I was going to talk about is if, like me, you think about the metaverse along the lines of the film Ready Player One. So with everybody running around with virtual reality headsets and wearing haptic suits, what's obvious from that, or what's going to happen there in data privacy terms, is that we are going to see a huge amount of personal data being collected through those headsets and through those suits. And not only is there a huge amount of data being collected, but also quite a lot of that data is potentially going to be special category data. So, for example, if you're creating a fairly lifelike avatar, perhaps an avatar you're going to use in a workplace scenario, or if your data is being collected about your physiological reaction to experiences in the metaverse, that is fairly likely to be special category data. And the problem that arises there is that a requirement to processing that special category data is nearly always going to be explicit consent. And then you have questions around how specific does that consent need to be? So, for example, do you just get consent once when the person enters the metaverse or their data is collected, or do you need to get consent for different uses? So let's say when an avatar goes to an art gallery or attends a pop concert or goes to an auction, do you need different consents for all of those different types of uses? So lots of data privacy related questions. We have the next slide, please. So I think I have very largely run out of time. I might just have time just to look and see if there is a question, which I don't think there is. So let me just wrap up generally, and then I can bring back Patrick and Claire to answer any questions that have been added on their bits while I've been talking. So I think what I've taken from both what I know about the metaverse and particularly from this evening are really the following things. So the metaverse is very much a real thing. It's happening now. There are big brands out there really sort of exploiting, using the metaverse. So it's something not to be ignored. And then the second thing is that clearly there are lots of different metaverses, and those metaverses have different applications and may well be suitable for different types of businesses. And then when it comes to trademarks, it's really important to review your trademark portfolio and make sure that it's suitable for the metaverse. And that applies equally to whether you've got any intention to enter the metaverse, or whether you just want it as whether you want your trademark as almost a defensive registration to stop other people using your brands in the metaverse. And then looking at IP agreements, I think the key thing here is really to review your current IP agreements, review your templates, and ensure that they are really suitable for the metaverse-enabled world.